This is our Judicial Roundtable, and this is basically, we designed this to be your opportunity to stand up at your seats and speak to four distinguished members of the bar, of the bench, from different jurisdictions, and ask away and express your concerns and get opinions from people who either did or are hearing our cases at both the trial and the appellate level. So basically, Patricia and I have a couple of questions that we have in reserve that we hope we don't need because we want you all to participate. But I know that Judge Gordy wanted to start off by saying a couple of words. At least that's what Patricia told me. And
Patricia told me to hold my water, so I guess this is the time to, just some thoughts. I must tell you that this has been, you know, when you're put on the spot and asked to speak and all the things run through your head about people are going to fall asleep and they're not going to ask any questions. I mean, this has been, I think I can say this for all the judges. Judge Smith and I have talked about it. It's been a learning experience for us. And you folks have been just wonderful, and thank you for the opportunity. During the course of the morning session, I was sitting just jotting down some random thoughts and bullet points, and I'm going to just run through some of them, and some of them we've already covered, and some of them may jog some controversy or some discussion. I think it was Mark Richard this morning who talked about jurisdiction often plays a role. Well, about maybe within the last 8 or 9 months ago, Judge Smith and I serve not only as our own private mediation practice, but we also serve as mediators on the Court of Special Appeals of Maryland, which has, which started about 2 years or so ago, their own mediation programs for cases in the appellate court, the first level of appellate court in Maryland. And let me tell you something, we all looked at each other like, what? It's hard enough to settle a case before it gets to trial. Now we got to try to settle a case after one party or the other has won. But it's working out great, and cases are getting resolved at that level. And every now and then we get together for seminars of our own. And we were sitting in a seminar about 6 or 7 months ago, 15 or so retired judges who were all involved in mediation. And the question went around the room and was posed to us, what do you think is the most significant part or the most significant issue in a case resolving by settlement or mediation? And there were a lot of discussions around the room about, some people thought it was the lawyers, some people thought it was the issue, some people thought it was the facts, some people thought it was the applicable law, blah, blah, blah. But the consensus at the group at the end was, and it surprised us a little bit, was that jurisdiction was the major factor. And we're not talking about state-to-state jurisdiction. We're talking about county-to-county jurisdiction within a state. When you try to explain that during a mediation to plaintiffs, for example, who are not familiar with the process, and sometimes adjusters, they look at you and say, well, isn't it the same law in the whole state? And isn't it applied under the same rules in the whole state? The answer to that is yes. But as we all know, different folks bring different attitudes and different perspectives depending upon the jurisdiction. Someone asked me a little while during lunch who was not familiar with Baltimore. He said, well, you're Baltimore City and Baltimore County. Are they not the same? I said, oh yes, just like New York and Mississippi. So jurisdiction is a factor. I heard Steve, I think it was, maybe I got the names mixed up, but whoever spoke this morning on behalf of the defense talked about settle as soon as you can. Well, Judge Smith and I looked at each other and said, well, that's a great idea. Except that's not what happens in our jurisdiction so far. Each jurisdiction has their own patterns and customs and mores. It seems like lead paint cases in our jurisdiction, much to the chagrin of the mediators and the court, seem to have a tendency to settle on the courthouse steps just before trial. And we'd like to change that culture, and hopefully you will help us change it, because we don't understand everything that you understand and all the issues and things that you have to deal with. Another bullet point I wrote down is that there are lawyers and there are litigators. And I must tell you that lawyer is a very generic term in our profession, but litigators are special, and they're special to all of us who were litigators before we became judges. But there are three kinds of litigators. There, in my opinion, there are litigators who are good at negotiations and settlement. There are litigators who are good at trial. But to be an excellent litigator, you have to be really good at both. And that's a very, I'm full of phrases and paraphrases, and that very good at both is a combination of being able to go to court and do what you need to do, but you got to know when to hold them and you got to know when to fold them. I have another phrase here, and it's not applicable to anybody here. But every now and then I hear a lawyer, especially at a settlement conference, saying, "Judge, we just need a trial. Let's just go to trial and get this over with." And I'm famous for having that look on my face. But behind the look, I'm thinking to myself, fools rush in where angels dare to tread. Trial should always be your last option rather than your first, because strange things happen at trials. Persnickety judges, disinterested juries, and sometimes even if you prevail, you all know that's just round one. Judge Smith, would you like to sing our song together about impatience? Impatience is enemy of mediation. We sing that song because many people, lawyers like judges, are always in a hurry. Especially the defense side comes to a mediation like, well, it's taking them so long. They know we're never going to pay that. Let's just get this over and go home. The adjuster and the defense attorney usually come to a mediation. They've been to several in the past. They've worked together usually. They know what they plan to do and what they don't plan to do. I think the plaintiffs come to the mediation. First of all, most plaintiffs have never been in a mediation. I'm reminded of, I called the lawyer's office one time and said, "May I speak to Mr. Jones?" And the secretary said, "May I tell him what this is in reference to?" I said, "It's in reference to a mediation." She said, "Just a minute." He came on the phone laughing. And I said, "What's so funny, John?" He said, "Well, my secretary just said there was a judge on the phone who wanted to talk to me about meditation." So it's for most of us, especially in lead paint, it seems to be mediation is a new phenomenon. But we certainly hope that it spreads. But I ask the defense especially, be patient with us mediators in a mediation, because it takes the plaintiff a while to go through and understand the process. They show up believing that they're driving a Rolls Royce, and during the course of the day it turns into a Benz, then it turns into a Cadillac, then a Buick, and I'll stop there. It takes a while to understand that process, and many times the lawyer for the plaintiff will confide in us, "Judge, I really need you to help me here with my client who has unrealistic dreams." That's the kind of information that is very helpful. Opening statements. Judge Smith and I have talked about this. Opening statements in mediation serve a purpose. I have a hard time figuring out what it is. Both sides know each other's case by the time they get to mediation. I have a lawyer who is very dear to me who loves PowerPoint presentations. He said, "Well, Judge, the other side has never really heard our side of the case." Well, what that PowerPoint usually does, it then takes me 2 hours to get the other side down off the ceiling, who have got an attitude over this half long-winded, very glassy presentation. I always say that, counsel, I invite you to make an opening statement if you believe that it will help us move the ball forward in the process. And then I say, but I'm not a big fan of opening statements. But it's your case, not mine, and if you're going to make an opening statement, please be careful what you say. Opening statements are the most effective from the defense, I believe, that begin with an apology that is not an admission of fault. Folks, I'm so sorry this happened to you. I really wish it had not happened. We believe that we have some defenses, but we're going to try to be fair here today and get this done. That is an effective opening statement. Running through all your defenses and whatever is not going to impress the other side, and certainly not going to impress the lawyer. We live in a society, I think it's the world really. We talked about the advent of the internet and social media. There's another thing going on in America, and that is we live in the world of excuses. Whether you're a landlord, whether you're a tenant, it's always somebody else's fault. You need to understand that concept for jurors. When jurors sit in the jury box and they've never heard a lead paint case or been involved in a lead paint case in their life, and you start talking about, yep, little Johnny the plaintiff, he doesn't pay attention in school, he's dropping out, he's got smoking dope, he's acting a fool, he's getting ready to get arrested. The jurors sit there and think, hey, my nephew acts just like that. That's it. Has nothing to do with motivation, parenting, etc. It must be lead paint. To be very, the landlord who says, well, I was going to get to it, or, I told the contractor to do it and he didn't, so be aware of this land of excuses that we live in. No one takes responsibility for everything. Finally, something that came up during this last session dealing with the record and making a good record in the courtroom. When I first became a judge, lawyers would come to the bench and say, Judge, can we go off the record for a minute? I said, sure, blah, 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 blah. And then I got this first opinion from the appellate court that said, this case is remanded for further proceedings to complete the record in this case. Lawyers used to come and say, Judge, can we go off the record for a minute? I'm like, why? And that was the end. And what we are taught as judges, and you need to understand, is that the record is our friend, and the record is your friend. With those statements, thank you for your attention.
All right. So we're going to open the floor. So we're encourage participation. So please, Steve.
So the majority of the time you go to court, and the first thing the judge asks is, what's the lead level? And I guess the lead level is sort of this common denominator in all the cases, and maybe people are conditioned to think of a case a certain way as a result of the lead level. So how do you feel about that? I mean, are you persuaded by it? When you hear what the lead level is that something that creates an impression in your mind as to what level of value this case may have? I mean, how does that work?
The lead level doesn't, in my opinion, operate in a vacuum. If I'm just told that the lead level is 38, and there's nothing else that's told to me, I still can't move forward because I need to know all those other criterion that I heard before. But, and I kind of cheated and looked at Patricia's questions she had written down. She asked, one of the questions was, how does this differ from a regular premises liability case? Well, the lead level is the starting point. Without the lead level, we really don't have anything that we can start with. Now, we know that there are lead levels that affect children, possibly in one way versus another, possibly based on their background, possibly there were things that happened during prenatal care. There's a host of things, but that kind of is, it's a lead litigation case. So that's the starting point. That's where we first look at it. Now, if you start off, you tell me, Judge, it's a lead level of 58. So the next question is obviously going to be, were there and how many chelations were there? Well, that's another issue that we have to look at. But you use that as the starting point. When I did my mediations yesterday with Patricia and Neil, the first question I did ask was what was the lead level. Then I asked about the kids' upbringing. Then I asked several other questions relative to the family. Then I went to Patricia and asked what the confounding factors were. And you look at it to offset it. Other than that, at the end of the day, you're looking at jury verdicts or other things and precedents.
Anybody else out there? Gus.
I have a question. In a case that's assigned to you for trial, and a lot of these cases are voluminous, a lot of motions to eliminate, what materials, if any, do you find helpful for the attorneys to provide you before they showed up? Once a case is assigned to you, say a binder of motions to eliminate, do you appreciate those gestures, trying to facilitate bringing you up to speed on what's to be in front of you, or do you not appreciate that?
Brian just used the binder full of women comment. I just want to out him on that. So I got flustered for a second there. I apologize.
What the motions, plural?
Yeah, no, I know what he said. I do appreciate I love to read. So I appreciate anything you want to give me, and I'm going to parse through it. I would recommend, if you haven't done it yet, in our last session, Patricia and her office had, with some cooperation from the judges here on the panel, put together 2 fact scenario cases. And those were it was really well done, because those were nutshells of what we like to see, because they help us to see what each side is looking at in terms of where the strengths and the weaknesses are. I would use that as a roadmap. It's a very good roadmap. But certainly, we're going to need to have the background to be able to review this case so we can come up with the right answer, and also so you have a good record.
I think there is a general perception amongst litigators that judges don't like to read. I'll stop there. And I must say to you that sometimes perception is based in reality, but I can tell you good, conscientious judges will read whatever you put in front of them, because it will help them be ready to deal with the weighty issues that come before them. I would recommend it, but I ask you to keep it within, if you submit a 40-page summary or trial summary, that's one thing. If you can condense it to something that is, approachable and readable, all the better.
That's a really good point, because when you are in it as the litigator, you're going to put everything in there but the kitchen sink, because you don't want to leave anything out. And we understand that, but by the same token, you need to step back and see what you need to get to us, what's important, so we can get through it in a timely manner for you.
Patricia, you had a question, I think?
I question that I have for the judges is, it's just something I think is thrown out there quite a bit. What do you see in terms of trends? And I will make that a 2-part question. One, what do you see in terms of just general trend of lead paint litigation? I think, at least in upstate New York, it seems to have sort of bumped up a little, but I mean, I think we understand that it's going to then decrease. And then what do you see in terms of, and this, to me, I'm thinking beyond lead litigation, just what I'm seeing in my other cases, just even auto accident cases. I come from Erie County, which is known as being a very liberal jurisdiction. I think still second to the Bronx only in New York State, so that should give you a picture of what I'm talking about. And at the same time, very recently, the jury verdicts have been more, for lack of a better words, they've been very defense friendly, and I think in large part because of the economy. I know I'm getting, no causes on auto cases that I would not have gotten in the past, and also verdicts that are significantly lower than they've been in the past, and I should be finding some wood immediately now that I've actually said that, but anyway, so what do you see in your jurisdictions, and Judge Rosenbaum, what have you been seeing?
Well, actually, you just pretty much said what I've been saying, so I'll defer to my colleagues in Maryland.
I mean, if we're talking in terms of jury verdicts, since I don't try, I try to avoid trying cases anymore, just looking at the reports and in the local legal newspaper, the Daily Record, I would say that verdicts in lead paint cases the cases that proceed to trial continue to go upward in terms of valuation. I mean, I guess the lawyers here could say better than I. And I see, the Sun papers, our local, newspaper, will pick up those kinds of cases. The Daily Record will pick up those kinds of cases. They get a good bit of publicity, and, you know, I wonder if that has some impact on, you know, what the amounts of verdicts are. I know in the medical malpractice area, there have been several, I'm trying to think if anybody here was involved in the last one, several enormous verdicts. There was a $55 million verdict in what I am told was a no offer case. And I think that might have been a little bit shocking to the defense in that case, and some others that have been substantial. So I think those numbers go up. I will say, in the motor torts, my experience, at least the last, I would say, 7 to 8 years before I retired, was that if there was a finding of liability, there frequently were not enormous amounts of non-economic damages that were awarded. There might be some or all of the medical expenses, some or all of lost wages, you know, some or all of, if there were some future economic damages. But if there were future economic damages shown, there would probably be a better non-economic damage. But the non-economic damage awards, if you look at it, would be surprising, and in effect, in some respects, even though a plaintiff's verdict really wind up to be a benefit to the defense, because the juries were not awarding huge amounts in the soft tissue kinds of you know, not you know, major serious injuries, but the soft tissue kinds of cases.
A good trend in Maryland is that more lead paint cases are coming to ADR process. I think 5 years ago it was almost unheard of that a lead paint case would be mediated. But it's beginning to turn from a trickle, it's certainly not a torrent. But the cost of, you all know, the cost of litigation, the cost of experts, the insurance companies are getting more cautious, and I'm trying to find the right word other than cheap. But they have stockholders and bean counters, and it's a business, and the economy's tough. But the trend is that more cases are coming to mediation, and I'm biased. And I'm biased not because I'm a mediator, I'm biased because I was a former trial judge. I think that you have very little to lose by going to mediation in a lead paint case, assuming that you've got it together and you're selective as to what case or cases you bring. Most cases that settle at mediation that day, those few that don't settle within usually 2 weeks or less following the mediation, because you've set the parameters, which sometimes you had no offer and unreasonable demand. And we do know that statistically, those cases generally, I'm beyond now just a lead paint, those cases, major cases that do not settle at mediation and go on to trial, usually result in some devastating effects to one party or the other.
One of the things that I think is interesting, if I can follow up, is that at least in the Circuit Court for Baltimore City, there are a number of categories of cases where mediation is required. Now, you can always, you know, opt out of it because in Maryland you can't require somebody to pay, you know, to go to a paid mediation, but at least there are the scheduling orders required. I don't think there is a requirement that the parties participate, and correct me if I'm wrong, but in the last 4 years, I don't think there's a requirement that parties in lead paint cases participate in mediation, but I would agree with Judge Gordy that, you know, that more and more those cases have come to mediation, and I, you know, perceive that as an interesting development where you didn't have to, you weren't kind of pushed to it, you know, or deciding that maybe, you know, maybe it is a good idea. For a number of reasons. I mean, one of the things I like about mediation is it gives everybody involved the opportunity to manage and minimize the unpredictability of the courtroom. Now, if there's somebody in this room who thinks that courtrooms have become more predictable places to work in the last 20 years, whoever that one person is, raise your hand, because I think it's, you know, even with, you know, the strongest case ever, everybody here has won a case, you know, that he or she knows should have lost, and vice versa have lost, you know, cases that were sure winners. And I don't know that that's going to change anytime soon. Just like mediation is a human process, the court, you know, the trial process is certainly a human process, and frequently cases are decided by fact finders, including, you know, judges alone, or juries that are based on reasons that have nothing to do with all of the technical preparation that you folks went through and what you put together and how you analyzed everything.
So we have 4 trial judges up here who've all been trial judges at the circuit court level. And as litigators ourselves, you know, we don't always get to talk to juries. Sometimes we do, sometimes we don't. So not necessarily from the judge's perspective, but if you've had the chance to talk to juries afterwards, what do you hear about what they like and don't like about openings and closings and how we as attorneys, as trial lawyers, present our cases, specifically in opening and closing?
Keep in mind that jurors watch television. That's what drives their psyche in terms of receiving your arguments and information from you. When they come home, the 5 o'clock news in 30 seconds or less tells them about 10 things that the news organization thinks is important. And so they're going to devote that 10 seconds or 30 seconds maybe to that, you know, and maybe, you know, then they're going to go cook dinner or do whatever they're going to do with their kids and the like. So you have, unfortunately or not, a short window of opportunity to persuade them. So you need to tailor your arguments accordingly so that they can receive them. And the bottom line is jurors are human beings. They like a little entertainment. They like something that they can understand. They want to like you. If they like you, even if your argument sucks, that might win the, seriously, it might win the day for you. But they have to like you. And they can only like you if you are persuading them. If you're explaining things in terms that they understand, that's not condescending or arrogant, that you just come across as a regular person to them. And so I think that's very important for purposes of opening and closing remarks, particularly the closing, because they've heard you all day, 2 days, a week, a month, whatever the case may be. They don't want you to regurgitate that week or day or month. They want you to hit the points that you think are important, that they need to know about, so because they want to make a decision. It's hard for them to make a decision because they do want to get it right 9 times out of 10. You know, because once they realize they can't get out of the jury service, then they're almost a captive audience. But they want to get it right. So make sure you're not regurgitating every single point that happened during the course of the trial. Touch on those things that are really important, that really persuade them, and will give them a sense that you are not being condescending to them.
Judge Houghton hit on a very important point. As I said before, my favorite part of this job is I love talking to the juries because they will talk to me in full. They will tell me 2 things every time. They will tell me if they liked you, and they will tell me if they didn't like you, but then they'll also tell me what witnesses really helped them come to their decision. They don't talk about the opening or closing statement. They talk about you and whether or not they felt they could relate to you and how you conducted yourself during the trial. So it is important to make that connection if you can, or at worst, be disassociated but not unfeeling, and certainly not someone who's going to come across with a personality that's just going to conflict with them. But quite frankly, and with apologies to Keith Vona, who's here I see, they don't care about the PowerPoint or the substance of that opening statement. They care about whether or not they liked you. And then they care about certain witnesses. I'll also tell you, I've never had a witness or juror, and I always ask this question. I'll go down the line and ask them how they felt about certain things. Not one juror has ever said to me that The Economist had an effect on them. It's always amazing to me, but by the same token, I think you need them. But, you know.
I want to follow up on something Judge Houghton said, and this is a true story. years ago, after a lengthy trial of some gravity, the jury returned their verdict and were filing out of the courtroom in a civil case. And one of the ladies, relatively elderly to me now, she's close to my age at the present time, said, "Could I approach the bench, Your Honor?" And I'm thinking, well, she wants to know where the nearest bus stop is or didn't get her juror pay, whatever. I said, "Sure, come on up." And the people are filing out of the courtroom. She comes up and she looks at me. She said, "You are nothing like Judge Judy. You are no fun at all." And it unnerved me so bad, I think I said, "Thank you." So television has taken its toll. To add to something that Judge Rosenbaum said is that I can tell you from my days as a prosecutor, I learned that jurors have to like you. I will also tell you they notice everything about you. And it starts before the case is called in the courtroom, whether you're walking on the sidewalk outside the courthouse, on your way to lunch, or you are on stage. And they can tell you whether your shirt is pressed, they can tell you whether your shoes are shined, they can tell you whether your skirt matches your blouse, they can tell you all about you. When you're writing while someone is talking, or while you're talking while someone is testifying, they notice that. And the reason is because they are captive. You can move and talk and it's fun for you. You're doing your thing. They're sitting there behind bars. And they have nothing to study. They do what people do. They start watching you. And at the end of the trial, they can tell you, "I didn't like her." Well, why didn't you like her? She looked at, I didn't like the way she looked at that other lawyer. Okay, that was a real important part of the evidence. So keep that in mind. Do not save your best suit or dress for the closing argument.
That's right.
Oh, one thing, if you are going to another jurisdiction, and because I also learned this, if they like Judge Smith, if they love her, if they love Judge Gordy, don't be argumentative with the judge, because they will feel that you are being disrespectful to the judge, and however persuasive you think that argument is in favor of your client, you will get zippity-doo-dah, because they feel you have come into their home and this is their guest, and you are being disrespectful and rude. And it has absolutely nothing to do with the content of your argument or your claim. Nothing at all.
Question up there.
On the reverse side, how would you suggest if a judge perhaps may be hostile towards one of the parties, the attorney, and because the judge definitely holds so much power for the jurors that they usually kind of take their cues from the judge, and if the judge is seemingly hostile to one of the parties, how would you suggest trying to diffuse that as an attorney?
Be respectful as you can, and present whatever point or interject whatever point that you think is important that the judge may have overlooked or has trampled on in some way. Because if you do tit for tat, it will backfire.
Make a good record.
Right, exactly.
Sometimes we try to make the record, but those off-the-record conversations or comments that are made off the record before jurors.
You can only do what you can do. I think that any lawyer who gets surprised by that kind of conduct from the judge didn't do their homework before they went into the courtroom. You are in a very difficult situation in that situation. You want to make a good record, you want to speak up, you want to let the judge know that, Judge, you're kind of like treating me unfairly here, my client, in the nicest way that you can, but it's a dangerous, the judges who were litigators before they were judges understand that, I think, a little better. But I think sometimes you just have to make your record. You might ask for a senior member of the firm. You know, every judge wasn't born a judge. We all have friends in the profession. We all have someone who can come talk to us without getting, you know, it might be like, damn, he snitched on me. So now I'm gonna really get him. But yeah, that can backfire on the judges too. So use your wits while trying to protect your client.
Try to, exactly. I mean, you do have to do everything you can to keep a good record because you very well may need it. It's very tricky. It depends on the judge, but if you feel that you have an opening, it also wouldn't hurt to try to approach the judge, ask to approach, bring the other attorney there, you know, and be careful how you phrase it. You don't know how fragile that judge's ego might be, but you can ask him if there's something you did wrong. You can apologize if you feel you need to, but you're in a very difficult position, and I'd like to think that those opportunities are few and far between.
And if you need to make a record, put it in writing, file it with the court clerk, get it stamped in, and take it up and hand it to the trial court clerk.
And start practicing in another jurisdiction.
No, we have done that we had to do that in a trial. Mr. Moore, who just stepped out of the room, had to do that during a trial that I had where he had trouble with the judge, and that's exactly what he did. And he filed it and stamped it in and then handed it to the courtroom clerk during that trial. Because if the judge won't let you make a record, that's the only way you can make your record for appeal.
I have a question building on what you said about juries never really saying the economist was the most persuasive. What did you notice about what's particularly effective with expert presentations when you're dealing with dense subject matter like lead levels or body burden or this kind of stuff that a jury may not instinctively understand the moment they show up in court?
You do need to have not just an expert, but an expert who can tell a good story. If it's dry, it's just going to go over their heads. It's not going to resonate with them. There's got to be, again, a personal connection. Interestingly, in our trial that we had last year, one of the parties brought in an expert, and the jurors said they were mesmerized by this guy. And I always talk to the attorneys afterwards and have a sit with them because I want them to always know that they did a great job and that this might be something they can build on if there was an area that could be critiqued by the jury. This particular expert, it turned out, they were stunned because this expert had been used in other jurisdictions within New York and was not a popular individual, which was a real surprise because he really did a great job. So again, I really think that has a lot to do with it. You've got to have someone who's not going to just spit back the material. You've got to be able to tell the story. You as the attorney have to have spent enough time so you've got a good rapport with him. So the jury is really listening and is engaged. And those are the ones that they will look at. They'll look at the witness, the party, the plaintiff or the defendant, but then they're looking at the expert and deciding whether or not this is credible. So it's got to be something that they connect with.
You know, I made light of Brian's comment about making a record about the judge who's less than judicious, but he's absolutely right. There are stories that we all know of certain lawyers who can no longer or will no longer appear in front of a certain judge. Sometimes that comes down from appellate fiat. Sometimes is a result of administrative decisions made within the court. The lawyer should not feel bad about that. The judge should. If you find yourself in a situation where you know if you're going to go in front of Judge X, you're going to catch the blues each and every time, you need to make sure on your client's behalf that you do whatever you can do to avoid that judge. So that's another delicate balance, but there are ways within the administration of the court itself where that can be discussed and dealt with. They're administrative judges, they're chief judges, they're whatever. but you need to find a vehicle, because you're not just talking about you getting embarrassed and beat up on. You're talking about your client being in a position where it appears they can't win.
Well, Judge Rosenbaum, I think, already touched on this. One of the questions that seems to come up quite a bit these days is, how do the judges view the use of technology in the courtroom? Is it a necessary evil, a tremendous benefit, useless? What kind of feedback do you get back from juries? And I suppose, Judge Rosenbaum, you can answer this as well, not just lead paint litigation, but any type of case on courtroom technology.
We have a courtroom in Monroe County. It's called the Courtroom of the Future, and it's already outdated. And a lot of attorneys, especially younger ones, who are very savvy when it comes to this type of technology, they enjoy using it. But one of my favorite stories is a medical malpractice case I tried, and this other attorney came in and didn't object to the use of the Courtroom of the Future. The one who wanted it had everything up on the screens. Each juror had his own or her own little device to review. We could edit things, bring them out, all that stuff. The other attorney came in with placards and beat the heck out of the other guy. So it really is how you use your time with the jurors. Yeah, if you have a jury pool of young individuals, they might be more interested in that. However, it really is your case. I mean, it's how you present it. This attorney did a fabulous job on just using placards that he put up on an A-frame and an easel to show individuals. The other one had everything all queued up, and he was also very good, but facts are the facts.
I think that jurors tend to like visual things, and this reminds me of a concern I've had for a long time. You know, we are not a society that processes large amounts of information auditorily, yet in the kinds of cases that we're talking about here, which may go on minimally for a week, many of them 4 weeks at a time, we're expecting people to sit quietly for long periods of time and process enormous amounts of information auditorially. We have become a visually oriented society. We are, you know, it's, as Judge Houghton said, it's the 30 seconds on the news, it's the sound bite, it's the picture. So I think that the use of technology that's well done can be very, very effective. The use of placards, the use of whatever, if it's well done, can be very, very effective. And if not, it can be brutal and it can be absolutely painful. I think sometimes also about, you know, when whoever it was in England who came up with this idea about a jury trial, you know, when the issue was, you know, did this guy steal that guy's pig? You know, everybody in the neighborhood knew who the pig thieves were. Let's be honest. You know, the jury of the peers, everybody knew who the pig thieves were. Now we're asking people to understand concepts about toxicology, concepts about medical, you know, impact, neuropsychology. You know, people who in many instances have, at least in our jurisdiction, you know, we don't get huge numbers of college graduates and PhDs sitting on our juries usually. So you have folks who have, you know, not as much education as the professionals who are presenting the cases. I've done a lot of work in the asbestos world as well, and my experience there was there's a lot of, you know, technology used, and the best teacher using that, you know, if you have a PowerPoint and the PowerPoint slide says every word that you were saying as you were going through, probably tends to just, you know, watch the blood gush from the juror's eyes as you're doing that. But if you have something that's, you know, snappy and colorful and it has, you know, the photographs can be, you know, if they are relevant to the case and they're not, what is the word, unduly prejudicial to, you know, whoever, then fine, use them. But, and it's probably worth, I think, you know, there's some really good services around now who, you know, obviously, you know, who help prepare, you know, the use of slides and technology and things, and having, you know, somebody at least for 1 or 2 times, you know, consult with about what's the most effective way to put some technology together that's going to be persuasive.
One of the things I've watched in the courtroom is a small thing, but I found it to be a killer for whoever uses it. Those laser pens in seminars are wonderful. In the courtroom, don't do it. Don't let your expert do it. It turns a presentation and advocacy into a lecture. For those of us who went to college, for those who did not go to college, a stick with a pointer on it or a finger is far more effective than sitting in your chair, you know, with a laser pen on a chartboard. So pass that on to your experts and some of your colleagues.
Oh, Judge Rosenbaum has one more thing.
Just have one thing that is in line with what we've been talking about today in the previous panel and this panel. I just want to say, you know, the word compromise is very important if you plan on settling your case, but there's two types of compromise. There's compromise, and then there's the compromise of your case. Never do the latter, but you can certainly do the former without doing the latter. Keep in mind that if you have an eye towards settlement, there's always going to be a little pain on both sides. That's compromise. Giving up your client's rights, giving up what your client truly deserves, is compromising your case. Don't ever do it. And the only other thing I want to say is, as I said, was my third year doing it, and I really do appreciate being invited back, but this has, to me, been the most enjoyable judicial panel I've been on in the last 3 years, and I really am honored to be with my colleagues from Maryland. It's been really wonderful.
Thank you.